Laura, thank you very much, and good afternoon, everybody, and welcome to today's webinar, Contracts and Limitations on Liability. My name is Craig Vaughn. I'm the president of Castle. For those of you who don't know Castle, we specialize in providing management services to apartments, condos, and HOAs in the state of Florida. We partner with approximately 300 associations in 7 different offices with approximately 1,750 teammates right now. Welcome to the webinar this afternoon. It's been an interesting time. I'm sure you'll agree. It does appear we're finally on the other side, or coming to the other side of the curve, so to speak, and we're very excited about that. I want to thank you for your leadership. Thank you for your search for information. We have more than 50 registrants for this webinar this afternoon. We've reviewed most of the questions are incorporated into the presentation that Steve's going to do, and I'm going to let him introduce himself in a second. You're welcome to continue to ask questions through the Q&A feature, which Laura pointed out early. I will try and work those into the discussion as we move through. At the end of the presentation, if we haven't answered your specific question, we will circle back for you, outside of this webinar. I will warn you that my head will bop and weave while we're doing this. I'm not falling asleep. Steve's presentation is riveting. I am just chasing down the questions and seeing where I can fit them in. So please understand that. We are using a Zoom platform this afternoon. As always, we check the Zoom platform performance. It's good, which is fantastic. So we don't expect any challenges, but if we have them, the simplest way to address that is simply log in and log out of the webinar, and it should reconnect fine. Before I ask Steve to introduce himself, I just wanted to remind everybody that it is not Steve's intention this afternoon to give legal advice to your association. Rather, we're having a conversation. If something comes up that is very specific to your association, we would urge you to seek the advice of your professionals and legal counsel. We are looking forward to having a discussion on contracts and liability. From the questions that were pre-submitted, there's lots of questions on liability, so that'll be an interesting discussion. Steve, I'd ask you to introduce yourself and your firm, and then take us through your presentation if you can.
Great, thanks, Craig. I'm Steve Addendum, everybody. Good afternoon. I'm one of the shareholders with Godey, Addendum, DeBost, and Cross. We're a full-service law firm, mostly in Naples, Fort Myers, Coral Gables, and Boca Raton. So I spend most all of my day working in the condominium and HOA world. So obviously we've been inundated with virus type issues. I'm sure we'll get into that today. But today I really am appreciative of the opportunity to address you and talk about some contracts basics and talk about some liability and limitations of liability issues. All of you, the good news if you're on your board is that you've all dealt with this contract stuff before. And so to run through what we're going to talk about, there's a couple of slides right off the bat we'll go through quickly, which are a little bit more academic in terms of what is a contract. But then we're going to have 6 or 7 slides with kind of the biggest, most common issues that you deal with on a day in, day out basis. If you haven't, you will. And so we're going to talk to you about what you should look for, maybe some quick fixes to make sure that you have a good, decent contract. And then as board members, kind of what is your duty to go through that process. And we've got a great knowledge base here with Craig as well. So he's going to definitely jump in from time to time and talk about from the management perspective, because this isn't just the lawyer's perspective, because management is carrying out a lot of the day-to-day operations and how these contracts work, and they're keeping track of a lot of these agreements. So that knowledge base is going to be great for a really great presentation today. So if I had to talk about what is a contract, the textbook definition is really an agreement between 2 parties that is enforceable, or where there's something in exchange. One person promises to do something, the other person promises to do something in return. And that something in return is worth something. It could be money, it could be a promise, it could be a promise to do something in the future, it could be walking away from certain rights. But ultimately, something in exchange between 2 parties, it can be oral or written. We're going to talk about that. And the next slide talks about the basic components. And so we could talk forever on this one slide, we won't. But an offer is when you effectively put out to the world or put out to an individual that you will provide this consideration, this compensation in exchange for something. And then it has to be accepted. In your world, the board approves contracts, and the actual acceptance is when it's signed and delivered back to the contractor or the vendor. So the ability to sign that contract is prefaced upon the board approving the contract. So many of your documents will provide that the president signs contracts, But that doesn't necessarily mean the same thing as the president approves unilaterally any agreement he or she wishes to. So generally speaking, the contracts or the bids or the multiple variations of bids will come before the board at an open meeting. You discuss the contract, you discuss the pros and cons, and you approve the contract. And when that's approved, the president's able to sign the thing and send it back. Now, Florida has what we call a mailbox rule, which means that the contract is actually accepted when you sign it and you place it back in the stream of commerce back to the other party. So obviously with email now, it's when it's click send on the email and it starts to go through that process. When using snail mail acceptance is when you drop it in the mailbox, okay? Now, consideration has to be something that goes back and forth. Consideration, again, can be money, something of value, or exchanges of promises, but you can't have a contract without consideration. It's not a contract. And so there must be something at risk for each party, right? And finally, the meeting of the minds is that we're talking about the same thing. And so if you're signing a contract to provide a pony, right, the question is, what kind of pony? What color pony? And so if you're not specific in some of those requirements in the contract, then maybe you don't really have a meeting of the minds, okay, and what we're promising to fulfill, okay? So that's, this last slide kind of sums up the academic side of this, but I want to talk quickly about the difference between void and voidable contracts, because we see it a lot in our context. A void contract is one that was never valid to begin with. And really what I want to hit home here, which is I think worth the price of admission, is the discussion on licensed work, okay? So Florida law provides that a contract for work where the vendor does not have license to do the work is void. It's as if you never signed it. It's an illegal purpose, illegal contract. The biggest, I think, offender that we've seen recently in this arena is remodeling contracts. So many of you are redoing your lobbies, redoing your clubhouse, and you're hiring an interior decorator to do this work, which is great. I have no problem with that. Except the scope of work will often include work that is under a general contractor's license. So while yes, they're buying furniture, they're buying, they're picking out colors and valences and whatnot, but it also might say, also we'll oversee the moving of this plumbing to a different location. We'll oversee and hire the contractors to build this bathroom. We'll hire and oversee this contractor to replace certain windows. And if that work requires a general contractor's license, that vendor, that interior decorator must have a GC license. And if not, the contract is arguably void. So that's a great example of kind of point you to this website that the DBPR puts out, which is the Division of Business and Professional Regulation. And they have a licensing portal. And so one of the first things we do whenever we review a contract is we run the name of the contractor, run the name of the person signing the thing. We run the name of the person holding themselves out to be the licensed individual through the portal and make sure it's a licensed contract. Because if it's not licensed, then while it may sound great to say, oh, great, I got all this work without having to pay for it because it was never like I never signed it, it's a heck of a lot more complicated than that, particularly when you start involving subcontractors and lien rights and everything. So it's really critical to make sure before you really get going on something that you make sure the person, if they need a license, they have a license. And it's not always enough to have the contract provide that they represent their licensed, because that doesn't make them licensed. So even if they represent their license, you still want to double check. And oftentimes you want to have them write their license number on the front page of the contract. Oftentimes they'll do that themselves, in which case it makes it much easier. But that's a big thing. Voidable, we don't see this as much in our world. The great textbook example here is the 17-year-old who goes to buy a car and the dealership sells him a car. When you're not 18, you don't have capacity to sign a contract. But when it comes to age or capacity or duress or fraud, these contracts are technically valid until someone's able to void them. So they're voidable, not necessarily void. So the take home from this slide really is to ensure that contractors are licensed, because even though it might sound like you're going to get a good break on an illegal or an unlicensed contract that is void, it really becomes a complicated situation. It's probably a great place to ask Craig, obviously, what they do and kind of how they look into the licensing information for some of their contracts.
Great question. We actually use a platform called VendorSmart, and in VendorSmart, we have the vendors upload their insurance and license information, and it gets vetted by VendorSmart, and then they go into our platform, which allows them to do work in the community. And so we make sure before, now this works for the association level, we make sure before the association gets involved with the vendor, they are verified in our system. So they have that insurance. We also have them represent that they do have, so we check that they have the license and that the license gives them the right to do the work that they're contracting to do. So that helps us as well. You know, the guidance we give to owners who are having vendors work condo specific more than homeowners association specific is that they make sure all the things you talked about are in line. So this is the responsibility of the board and an individual owner in a you know, condo or an HOA.
That's great. That's also a great tool. That's not something that I know is standard out there. So with respect to now the basic nuts and bolts, well, what about the actual piece of paper, the literal piece of paper? And so the textbook case is the situation where a couple has too much to drink in a bar and they sign on a paper napkin that they're going to sell the farm to their neighbor for a certain amount of money. And so this brings up this textbook thing called the statute of frauds. And if you want to skip to the next slide, the answer is that you can have oral contracts, but some contracts are required to be in writing. And whether you're a condo co-op or HOA, there's actually a statute on this. It codifies the statute of frauds in the statute itself, in the 718, 720. And it does provide that you need a written contract for something that could not be performed within a year. Most service contracts, literally the statute says that, and anything to do with dirt, with real estate. So if you're talking about purchasing, leasing, renting, all these things have to be in writing. And so the overarching theme here is that although you may not need to have it in writing as a result of the statutory requirement, the next slide talks about the reasons that you do actually need and should want written contracts. Whether it's for the quick fix or whether it's for a multi-million-dollar renovation, the written contract is what prevents the association. There are common law and there are statutory rights. And so even if we don't have a written contract, there are common law provisions that have come out through case law through hundreds of years, and there are Florida statutes which could kick in. Problem is, those aren't always in your favor, right? You don't necessarily always want what the statute has. And so having a written contract will provide objective measures for performance, hopefully, right? So it can prevent disputes as to whether or not someone's performing. It can set those performance requirements. It can provide your recourse or the other party's recourse. And note that many management firms will require you that you have written contracts and require that you have certain provisions. Your insurance carriers, I've seen recently a number of insurance carriers saying, what do you mean you don't have a written contract? We require as part of our coverage of you that you have written contracts that have certain provisions such as waiver of subrogation insurance, which we'll talk about in a couple slides. But you may be required through these other third parties to actually have written agreements that govern what you're supposed to do. Otherwise, how are you supposed to know who is to perform, how they are to perform? And if something goes wrong, how do you fix it? And then the more important question is that if something goes wrong and one of your owners comes to a board meeting and starts pounding the desk and says, how in the heck did you let this happen? And you say, I don't know, we just had an oral understanding about doing this work. And all of a sudden you've got yelling and screaming at board meetings. And so we'd like to avoid that for you as well. Okay.
Steve, can I circle back just on there's a question on contract signing, which I think is a good one and often gets asked. What if someone other than a board member signs the contract? So, you know, you go to let's assume first that you go to a meeting and it's approved and someone other than a board member signs it. Is it valid? Is that something that's a concern? And I guess we're also talking about a situation where a board member goes off on their own and executes a contract on behalf of the association.
Yeah.
How would that work?
So this is the your lawyer's favorite answer, which is it depends. Okay, you've all heard that a few times. It comes down to this concept called actual versus apparent authority. Okay, so the officer of an organization has apparent authority, meaning when you're the president or vice president, that title carries some weight. We wrote in one of our newspaper articles a couple of years ago, my partner Richard wrote that being the president is like being the king or queen of England. It's like a great title, but very little power. And we ended up getting in really rough waters with one of our clients because all his golf buddies ended up calling him Your Majesty for a couple of weeks. And he was not happy about that. But the point is that just because you have a title, it doesn't mean you have the actual authority to sign a contract, but the rest of the world might not know that. So when you go to the Division of Corporations website and you see the corporation, you look at the list of officers, and maybe you see this person's name listed there as a secretary, vice president, or president. And so the other party looks at it and says, you know, Jane Smith says she's the vice president. She's an officer. She's on the website as an officer. I have no reason to think Jane Smith doesn't have authority, and I have no reason to think that this wasn't approved by the board. And so when you have that, and then the contractor acts on that signed agreement, guess what? You got a contract, right? Unless the vendor knew or had reason to know that you didn't have authority to sign it, you've got a contract. And so the association is going to be on the hook for whatever has been signed in the name of the association. That's very different from having actual authority. Actual authority comes from the board resolution, which grants the ability for the officer to sign the thing. So the board vote opens the door for the officer to walk in, sign the contract, and then it gets mailed or emailed back to the vendor. A great example that I've seen of this, I saw a contract for this cable negotiation, right? Some of these cable consultant agreements. And this thing was a six-figure contract at the end of the day. And it was signed by the president, and there was no board meeting to ever actually approve the contract. And so from the vendor's perspective, he's owed the 6 figures. Now, the new board comes in because that board got elected out, and all of a sudden they get the bill for like this quarterly bill for like $20,000. And they're like, what the heck is this? They can't find it in the minutes. They can't find it anywhere. But it turns out the vendor has this signed agreement signed by the president and the vice president. So that was a really big mess. But ultimately, the association is on the hook for that. And so if you have a situation where you have people signing contracts who are not authorized to do so, you're putting the association at risk because it could still be liable. But ultimately, the question is, was the vendor reasonable in relying on that? And so what I recommend a lot of people do is that as part of the motion to approve a contract, I also recommend you put in the motion who's going to sign it. So this is good for the person signing it because they're sticking their neck out there. So if you're going to have anyone other than the president sign this thing, it should be, I move to approve the landscape maintenance contract and I authorize the vice president to sign on behalf of the association. So that gives apparent and actual authority to the person signing. So that's a great question. It's a very common situation that we deal with. But having a title does not give discretion to approve a contract. The board gives the authority to sign the contract. But that title can it can be a curse and a blessing because you have the ability to bind the corporation even though you never got the authority in some instances.
I think that would get chills to some board members.
Right, for sure. And we commonly see the argument that, well, because it's in the budget, it's there, the contract's therefore approved. And that's not true. Just because you budget to set aside money for something doesn't mean that it's approved. And so you set aside $100,000 for new shrubs, for example, and which is possible. And then all of a sudden, the landscape committee chair says, oh, I've got $100,000 of shrubs. I'm going to go ahead and call the vendor and sign $100,000 of landscaping requirements. Now it comes back that this person has the title of landscape chair. They've been working with the landscape chair and the vendor for a couple of years. They've always taken direction on small things from the landscape chair. So why should they think any different when the landscape chair signs a 6-figure contract for shrubs? And then the board comes back and says, why did you do that? We were over budget on everything else. We don't have $100,000. And now you've got yourself the definition of rock and hard place. And so that's why, let's talk about the recommendation there. The recommendation there is a charter. If you're going to have committees, have charters, which may literally say you don't have the authority to sign a contract, even if it's budgeted money.
Right.
That way, when the person signs the contract, they knew they didn't have authority to sign that contract. You might still find yourself in a difficult position with the vendor, but obviously maybe there's some recourse there about someone acting outside of their corporate authority. It's called ultra vires in Latin, acting without corporate authority. And so you want to make sure that people are acting with the authority which is given to them by the board.
Excellent guidance, Steve. I know I derailed you there a bit, so we can get back on to our program.
That's great.
But that's great advice, I think. Thank you.
So I have a longer version of this presentation that's in there. So it was appropriately included. So quickly going through this slide, the deal is that you have to have certain terms. You can't have an open-ended contract or else it's what they call illusory. There's no real promise if it doesn't actually provide some specifics. And so if you're selling real estate, for example, you don't have the price, you don't really have a contract. If you don't have the names of the parties in the contract, you don't really have a contract. If you don't have some specifications, you don't really have a contract. Otherwise, no one can hold your feet to the fire in terms of what you're actually supposed to do. I call this the one-page estimate. And this is one of the things that drives me absolutely crazy, is that I can't tell you how many contracts I've seen for $40, $50, $60, $100,000 that are one page that say proposal or estimate at the top, They have some subjective things they're going to provide, some not very clear things. And it says sign below for acceptance in the name of the president. And then of course it says, you know, payment due on demand, interest and late fees if you don't pay on time. That's all you get. That's all that's in the contract. But if there's the name of the parties, a dollar amount, and some sort of specifications what they're going to do, guess what? You got a contract. It's a crappy contract, but it's a contract. And so the more you get into these dollar figures, the more risk that you start to run. And so if we go to the next slide, I think we're going to start to get into really the nuts and bolts of the presentation, which are these six different sections in terms of what you'll see the most often. And really when you're looking at a contract, what you might be needing to look for, talking with your manager, talking with your attorney. For example, those one-page contracts I talked about, a great fix is having a standard addendum, right? We routinely do this for clients where if you don't want to have the lawyer, you know, negotiate a contract for, you know, $13,000, then maybe you have a standard addendum that you add on to the contract, which has these basic protections in there. It's not a one size fits all. It's not always a replacement for legal review, but it can be a great tool to give yourself some meat and some bones to an actual contract. Because that one-page estimate is a contract, but with no protections for you. All right. So going into each one here. So termination. So this is definitely where Craig will be able to step in, because I'm sure he's seen a lot of situations where boards want to change vendors, but don't really know how. And so the key here, if you listen to anything else, listen to this, is that not all contracts can be terminated with or without cause. There is nothing in Florida that says any contract can be terminated with 30 days notice. It's actually the exact opposite. The default rule is that you have to have a breach to terminate a contract, meaning you have to have cause. Many of you will require, and I recommend that you do, and maybe your insurance carrier does as well, require that all contracts that you sign be terminable with or without cause. That means you can terminate the contract because the sky's the wrong color blue that day for any reason under the sun. Obviously, when you get to like replacing ACs on high rises where it requires cranes and stuff like that, it's not going to work. You're not going to have that much flexibility because of the prep time, the prep cost. But with most contracts, you can provide termination with or without cause. So if you're talking about the irrigation contract, which is the worst ever, or elevator maintenance contracts, close second to being the worst ever, then you talk about, well, we're going to properly inspect the irrigation. We're going to make sure there is sufficient coverage. All right, what does that mean? And so if you're in talks with the irrigation contractor, they're going to say, what are you talking about? There's sufficient coverage. It's like 92%. And you say, that's not sufficient for me. Well, who gets to decide sufficient? Guess what? A jury. You don't want to be in front of a jury. You want to be able to say, I'm going to change contractors because 92% is just not enough for me. And why? Because I say so. All right. So what does this mean? It means that you need to be aware of auto renew clauses. So if a contract is not terminable with or without cause, meaning you can only terminate it with cause, then you have to know if this thing is going to auto renew. Many contracts will say that this agreement automatically renews for a whole nother term, could be 2, 3, 4, 5 years. If nobody terminates the thing 60 to 120 days beforehand. So if you don't have a spreadsheet that indicates whether you can terminate with or without cause and has a notice date for termination, then you're definitely on the short side of it, because you need to know if you don't like this vendor, we may not have the ability to terminate without cause, but we can terminate because of time. And we don't want to miss that deadline. All right. Why it's important is because many contracts that we see are just awful. And even if there's the worst breach in the world, you'll never get out of it. Example, you might have a contract that says if a party breaches, the other side must give 15 days written notice by certified and regular mail. Following the 15 days, the other party has 30 days to reasonably cure. Following that 30 days, the parties must mediate to determine whether or not there's an appropriate cure and a resolution can be reached. And if no resolution can be reached, the other party can then send another termination notice by 15 days certified and regular mail to actually terminate the contract. So you may find yourself in a situation where despite the worst breach, you'll never be able to get through the red tape. So that's why it's really critical to cure with or without cause. The final point I want to make is about dispute resolution, which is exactly what I just mentioned, which is that if you want to have a trial, jury trial, if you want to have arbitration requirements, if you want to have mediation requirements, if you want to be able to skip any of that with a vendor, you want to be able to know how you're able to get recourse in the event of vendor breaches. And so having some very basic terms in an addendum or in your 30-page contract for $10 million, it's critical. So Craig, I mean, what are you seeing in the industry in terms of which vendors is this most critical for, or is it most helpful to have?
Well, I think it's a great idea. It's quite honestly something we advocate on behalf of our associations, because we all love attorneys and they're all afraid of the cost, but it's short-sighted. I mean, that's really the case. But the other thing I would say, and we see as the contracts get more sophisticated, it's even more important to have an addendum like yours, because boards are fooled all the time on the auto renewals and the premise under which they can terminate them. And, you know, lots of times now the auto renewal and the termination provisions are buried in a terms and conditions, which are linked to a contract, which they direct you to a website and go and look at, and you accept the terms, and all of a sudden you don't have the protection that you want. So we see all of that stuff all the time, Steve, and I would continue to advocate for at least a standard set of terms and conditions that says, notwithstanding anything in this agreement, we agree that it term ends, or we can terminate without cause, or it does not auto renew, or auto renews for successive periods of 30 days or something along those lines. But I think you've outlined two pieces: the one-page agreement, which is a proposal, right? I'm just going to submit this proposal to you. That becomes a contract. We see that all the time. And then we see contracts trying to work around not being able to be terminated with reasonable provisions. I will tell you, our contracts are all 30 days with or without cause, because that's the nature of the business and that's the right thing to do.
Great point. The other issue to really remember is that if you think that you can terminate this contract with or without cause, and you don't really have the right to do that, and you fire off a termination letter, guess who's now in breach of the contract? The association's in breach of the contract. And so you don't want to find yourself in breach because you thought you could terminate with or without cause. Okay, this is the slide on exculpation provisions and limitations on liability. And I am seeing this more and more and more. So what we're talking about a contract that says, notwithstanding anything else in here, in the event I mess up, the only thing I have to pay you is what you pay me. All right, we're seeing this all over the place. That notwithstanding all the damages I caused, even if this crane caused something to fall on a human being and they died, the only thing I owe anybody is the $10,000 fee I got paid to do the work. All right. So this is most common in professional services agreements, like engineering agreements. We're seeing it a lot, but it's also expanding. You're seeing it in home inspector agreements. You're seeing it in most thought through contracts that are being circulated out there. A point here is that Florida takes some pretty unique interpretations on this in terms of was it mutually discussed? Was it mutually negotiated? Is it enforceable outside of the professional services context? And even if it's not enforceable, it's still a messy situation, because guess what? That's going to be their defense in the event that you sue them for more than that fee that they're being paid. Another version of this that we're seeing is saying that if I mess up, the only thing I'm liable to you for is the amount of insurance coverage I have, and only if there's insurance. All right. Well, let's take this next step to COVID-19. Right. So the COVID-19 discussion there is, guess what? There's no insurance for this stuff right now. The vendors, the insurance carriers are saying, we're not going to cover claims arising out of related to COVID-19. And so it's a really interesting question as to how do we deal with this? And that's why these limitations on liability can really be damning in a way, because you might literally have death. You may literally have a very, 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 very awful situation where the damages are astronomical. And if that's the case, and the person who's responsible has this provision, they might say, I'm really sorry this happened. Here's your $15,000 back. That extra $1.5 million, that's on you. All right. So look for this. We're seeing it all the time. If you're not looking for this, it'll be snuck in there. Get rid of it at the onset. Okay. All right, the next slide is going to talk about insurance. I know there's some questions on insurance as well. So you want to have minimum coverage requirements. All right, we put this in our standard addendum that we talked about earlier, standard minimum coverages. And obviously the amount of coverage is going to depend on the situation. If you're building a seawall, you're going to want more insurance as to whether you're changing some light bulbs, all right, obviously. Additional insured status. Why this is important is because we routinely see contracts that say the association is an additional insured, but the vendor never actually does it. So what does this mean? And these last two points go together, is that when the association is named as an additional insured party, it's like the vendor's insurance is your insurance. All right? It's like it's your insurance. You can go to them when there's a claim, even though you're not paying the premium for it. So first things first, you want to get that insurance certificate from the vendor that has your name on it. It's not enough, in my opinion, just for them to promise to put your name on it. You want to see that thing. Otherwise, it didn't actually happen. And so if that insurance isn't available to you, then you're stuck going to your own insurance. Now, here's where it's relevant. The other provision that you want to put in there, and this is super complicated, is this idea of primary non-contributory provision. And what it boils down to is that if you don't have language in your contract about this primary non-contributory, their insurance is going to say, wait a minute, the only reason we're insuring you is because of this contract. And we don't like that. And so we want you to go to your insurance company first. And so what happens is that you go to both insurance carriers. You go to yours, you also go to the vendors. And they end up splitting the baby a lot of the time, but the result is that your premiums still go up. And so what it means is that if you can get yourself named as an additional insured party, and the contract provides that you are primary and non-contributory, meaning that the vendor's insurance is the first bite at the apple, then you should never have to go to your insurance carrier, okay? So what it means is that when you have indemnification with a vendor through contract and they screw up, but you get sued anyway, you can go to their insurance, and you can go to their insurance before you ever have to call your own carrier. But if you don't do it right, you're going to end up with your own carrier. You're going to end up with premium increases, and you're going to end up in a sticky situation. So if you get that done at the forefront, then you can save yourself a lot of headache if things go wrong. A lot of people don't understand this. If you ask 10 lawyers, you'll get 13 opinions on this. It's a very common situation with really anything with lawyers, but in this one in particular. And the final point there is don't forget auto. All right, people are driving on your property, whether they're in their own car or whether they're on the carrier's vehicle. I'm sorry, the vendor's vehicle. They're driving your property, and you need to make sure there's auto insurance. So sometimes it's buried in comprehensive commercial insurance. Sometimes they list separately auto insurance. But don't forget that. If they're going to be driving on your property, especially with trucks, make sure that they're having auto insurance available to you there. So Craig, I'll make sure, I know there were some questions. If you want to jump in or if there's anything else asked that maybe we could answer there.
I do. I think there are some questions. Before I got there, I would say that, one of the things we've learned through the COVID situation is a lot of potential claims won't be covered. But we see a lot of focus on insurance is how much is my insurance renewal going to be, and not so much really getting an understanding from your broker of what are my options. And we now have learned that there are two distinct types of D&O policies, kind of a wide band and a narrow band one. And, do you know what is insured, and do you understand what is excluded from your insurance so you can mitigate risk around those types of issues? Mm-hmm. So really, your insurance agent is one of your professionals that you're depending on, and their sole job isn't to get the lowest price on insurance. Their job is to get you appropriate insurance for your circumstance. So I would encourage that meeting to be not 10 days or 2 days before the renewal, but really have a sophisticated process around renewing your insurance. Mm-hmm. And I think that'd be the biggest one. There was a specific question I wanted to get to here, Steve. Give me one sec. It was around D&O policies, and it's interesting for now. But the real question was who is covered generally by a D&O policy, and this may be outside your purview, but who is basically covered, and what do you need to do kind of protect yourself at D&O insurance?
Sure, that's a great question because it actually is exactly on point with the slide in front of you on indemnification. So D&O is directors and officers insurance. It's relatively cheap, okay, relatively, and it's what protects the board, what provides that liquidity, and you get what you pay for. But there's a reason, just like Craig said, there's a reason why these policies are not 5 pages. They're actually 30 pages because there's 25 pages of exclusions. All right, so you want to know what you're covered for. Now, indemnification is when either the individual directors, is when the individual directors of the association are sued and you think, well, someone else is at fault here, I should be covered. And so the context that you see it is if you as a director are individually named in a lawsuit. And if that happens, you look to your articles of incorporation, and typically it provides that the association will indemnify you for anything that you do in your capacity as a director. So if you're acting as a director and you're doing something and it turns out someone got hurt and the association got sued, the idea is that, well, you shouldn't be held personally responsible for legal fees to defend yourself and for damages as long as you were acting in your capacity as a director. But now the association has to pay for that. The D&O insurance is the liquidity to fund that, right? And so the insurance is there to defend you when you are entitled to indemnification under your articles of incorporation for acts that you take in your capacity as a director. Now, to go back to the question as to who is actually covered is interesting because the insurance will generally cover directors, officers, and committee members, which is why it's critical that you actually appoint people to committees at open board meetings. So there are minutes that show that this person was actually appointed to a committee so that they can have this insurance protection available to them. But just because the insurance is there, it doesn't also mean that they are indemnified. I read a provision of indemnification yesterday which said they're only going to indemnify directors and officers. And so if you're a committee member, you're going to say, well, I'm not indemnified. The association doesn't have to defend me, even though there might be insurance available for the purpose. And so you want to look at your provisions under your articles of incorporation and bylaws, and you want to talk to your insurance carrier and make sure that you know what is under the umbrella and how far that umbrella actually goes. Okay.
Steve, can you comment on that? I know the statute and your documents provide you some indemnification as a board member director. Can you comment on that? And then specifically, there's a question one of our webinar participants asked about if you get guidance, i.e. from your legal counsel, and decide to act contrary to that, does that potentially take you out of the indemnification language or opportunities that might be available?
Sure. Fun discussion. You can have lots of horror stories on this. All right. So the first part is that the statute essentially provides, under the not-for-profit statute, essentially provides that you're indemnified for anything except for stealing from the cookie jar. So the statutory default is that unless you're stealing money with misfeasance or malfeasance, then you should be indemnified. However, it also provides notwithstanding or except as otherwise provided in your documents. And so this is where you see a litany of different provisions. And for those of you who have original developer drafted documents from 20 years ago, who knows what the heck the thing says? I've seen provisions that talk about the indemnification can be canceled by a board. And well, what if the board changes hands and the other side gets on? Now all of a sudden, can you cancel the indemnification that the previous board got to enjoy? I've seen provisions that say that you are indemnified unless you are criminally adjudicated to be have committed a crime or fraud. And so it really is document specific as to what will be indemnified or when indemnification will not be available. All right, but indemnification is a really interesting point because as a director, you're volunteering for this stuff, right? And so the salary is not great, let's face it. The great example that I talk about is building a bridge. Let's say you have a bridge in your community and you have to rebuild it. And you look around and you say, well, we don't want to hire an engineer to draw specs. Oh, and Jim down the street, he's an engineer, right? And someone says, yep, Jim's an engineer. Well, is Jim licensed in Florida? It doesn't matter, he's an engineer. Like someone told me that he was an electrical engineer. It doesn't matter. He's an engineer. It's good. He can build a bridge. So Jim says, yeah, I'll do it. Save the buck. I'll draw your specs for a bridge. And so the contractor gets those specs and he carries out those specs perfectly, but the bridge collapses, okay? So in that context, you might be personally liable, right? So following business judgment typically means making informed decisions and following the advice of professionals when the advice is necessary. And so if the board knows that they don't have a licensed engineer drawing the specs and the thing collapses, you could be deemed grossly negligent in that context, not just negligence. It comes back to whether or not you're indemnified for gross negligence. Maybe you are under your documents. But if you're not, now all of a sudden the question is whether I did it properly or not. It goes back to that phrase of ultra vires, outside of your corporate authority. Let's take the same bridge, but let's say they hire a licensed Florida engineer. They get the specs. The contractor carries it through perfectly, but it's just there is a problem and the bridge collapses. In that case, the association won't be liable. The directors won't be personally liable because if you're not an engineer, you don't play engineer. And when you rely on those professional recommendations, you're exercising business judgment. There are a number of cases out there that say a judge will not second guess the directors on their discretionary authority as long as they're exercising business judgment. And so if you hire the licensed engineer to build the specs for the bridge and it collapses, someone's going to be liable, but it's not going to be the individual directors because of gross negligence, right? And the more grossly negligent, if I can use that phrase, the more outside of the realm of business judgment we are, the more likely your carrier is going to deny coverage when you go seek D&O insurance. So it's really critical that you know what that umbrella is. And so look to your documents for what is indemnified and know what insurance is available, and know that if you rely on professional recommendations, and this is obviously this is self-serving as the lawyer who writes the opinions, right? So, but when you rely on those opinions, you will be deemed reasonable in the context.
That's excellent. That's great guidance, I think, for our participants. So thank you. Okay.
Two other. Yeah.
Go ahead.
Go ahead, Craig.
No, on you.
So the last two provisions that I think are critical that you see from time to time are venue and attorney's fees. Venue is easy. Where are we going to sue? The default in the common law is that for a contract, it's the county where the contract was entered into. But what if the contractor is based in Miami and you're in Naples and the emails went back and forth? Well, where's the contract signed? It's difficult. And secondly, torts, claims for negligence are where the tort was committed. Again, because of electronics and technology, it's kind of difficult to prove where the tort's always committed. So you can put in there that venue shall be exclusively Miami-Dade, Palm Beach County, Lee, Charlotte, Collier, so that you don't have to go across the state. But what you need to look out for is, for example, the like alarm monitoring agreements, maybe the third worst ever contract that you see. They'll typically say that venues in Texas. Well, guess what? You got to go to Texas to litigate this thing. And so you want to look out for that to know that where you actually are going to be debating this stuff. The attorney's fees is important to know because it's a double-edged sword. And what I mean by that is that there's a provision that'll say typically that in the event of litigation, the prevailing party recovers their attorney's fees and costs from the non-prevailing party. And so this is helpful because if the contractor screws up and we're only talking about $50,000, then you don't necessarily have to think to myself, well, if I'm going to spend $30,000 in legal fees, then why is this even worth pursuing? So when you got a good case, you know that those attorney's fees are also leveraged to compel the other side to act because they'll know that they're not going to be responsible just to fix the thing, but your cost to go chase them down. Now, in your context as board members, you're more likely to breach by not paying, right? That's usually how you breach, by not paying for the service. And so likewise, if they have to come after you for the attorney's fees, then you know, well, maybe I'm trying to save a buck here, but in the same token, I might have to pay their attorney's fees if they actually sue me. So it is a double-edged sword in terms of having leverage and also defense. But this really goes back to having objective measures, right? So if your irrigation contract says that we're going to provide adequate coverage, then you need to know that when you refuse to pay because you got dead landscaping, and the irrigation vendor says, oh, it was the prior vendor's fault. That's what they always say, is the old person's fault. I'm going to sue you and you're going to owe me attorney's fees. Then you need to know to yourself, well, what does adequate coverage mean? So even though they may have done a crappy job, you're stuck with a contract that provides a subjective measure of interpretation. And guess who does subjective measures of interpretations? They're factual questions for your peers of juries and judges. So take control of that and say, for example, require weekly checks, require supervision, require attendance with a committee member of the wet checks so that you actually see what's being covered. Like, try to put some objective measures in there. Don't just say we're going to mow periodically. Say we're going to mow 52 times a year, stuff like that. That'll help you use the attorney's fee provision as a sword, as opposed to it being this ambiguous provision that both sides fear because you really don't know who's right and who's wrong with subjective measures.
Great.
So running through some other provisions which are common. Proof of insurance, we talked about that. You want proof. You also want proof of cancellation. Who pays for permits? If you don't say it, you're going to be fighting over it. So put clearly who pays for permits. Time is of the essence. Yes, it really is important. Because if you have deadlines in your contract, when you make this stupid 5-word phrase, it means that you can hold their feet to their fire for those deadlines. In the context of a commercial, I was a lawyer for like 8 days, and I got stuck in a commercial sales contract or arguing over time is of the essence. And trust me, it's really important. No assignment. If you vetted a vendor and you signed a contract with a great vendor, you don't want them to be able to assign it to mom and pa's, cable shop. Now all of a sudden that you have bad service, and if you have a 3-year contract, you might not be able to get out of it for the 3 years, even though it was assigned. So you want to be able to prevent assignment to somebody that you've never worked with and you don't want to work with.
Steve, can I interrupt you with one question there? There's a great question. It has something to do, I think it fits into assignment, excuse me, but you hire a irrigation vendor, you check they don't have the appropriate license, and they say, well, I'm working under the license of the landscaping company. Mm-hmm. What type of problems does that create for the association and your guidance to them?
Well, the first answer is that it's possible. It's possible that's true. Okay, you can qualify other people with your license is the phrase. So you can go through the process of qualification with the DDPR where you can act under someone's license. They're putting their own neck out there for you to act under their license. The problem is, as you may have seen, and my dad was a contractor, no knock on contractors, but a lot of times there's the, oh yeah, just use my license. Mm-hmm. But they don't actually do the paperwork. And so if they didn't go through the process of getting the actual qualification, guess what? You got a void contract. It's as if you never signed it. And so it creates a huge mess. And so it's entirely possible that you could act under the license of another person, but you have to be properly qualified. And there's actually columns under that DDPR licensing portal where you can see qualifications of other parties and who's qualifying who. So you can double check that. Excellent, thank you. Yep. Progress repayments, super important in retainage, because if you pay the vendor up front, guess what? You're not going to get that punch list at the end. And so if you want to withhold 10% of each payment until the very end, great. But if you don't put that in the contract, guess what? You ain't going to get it. And so you want to be able to make sure the vendor completes the work and goes to the punch list. So that progress payment and retainage can be great. Changing the contract in writing only, that's pretty critical as well, so that if you have a side discussion, obviously it's not going to be binding, right? So if someone doesn't follow through on that, you want to be able to point to written amendments, written addendums. Non-waiver of breach, what this means you see a lot, it means that if I ignore that breach on Monday, but then we have a falling out on Wednesday, and you breach on Friday, I can still hold your feet to the fire. I mean, just because I ignored a breach last year doesn't mean that I have to ignore all future breaches of that contract. But you want that to be in there so they don't argue you waived it. Counterparts, this is where you have someone signing in Tampa, and then the other copy is signed separately in Palm Beach County, and then you put them together even though they didn't sign the same document. All right, that's really helpful as well. And then no bias against the drafter. So there's a common law thing in Florida that says if you drafted it, ambiguities are going to be construed against you. So what that means is that if you meant for something to be clear and you drafted it, you better make sure it's clear. And if it's not clear, we're going to basically find in favor the other party. And so it's really helpful to have a provision that says both parties acknowledge that neither one drafted this thing and that we both agree that we had input in the language that we're using. And so the words that we're using, we both meant to use. Okay. All right, so this pretty much is wrapping us up into some special situations that we see. So real quick, because I know that this always gets asked, what about bidding? So Florida law requires that you obtain competitive bids. So as board members, it doesn't say 3, it doesn't say 5, it says competitive bids. And so what that means is apples to apples comparisons. And so if you have one vendor prescribing and bidding on hurricane impact windows, and you have another vendor bidding on non-hurricane impact windows, do you really have competitive bids, right? You want apples to apples comparisons. And the threshold to do that is different if you're in a condo or an HOA. So if you're in a condo, it is 5%. Take your budget, take your all the expenses, including the contribution to reserves that year, multiply it by 0.05, and anything above that threshold requires competitive bidding. If you're in an HOA, it's 10%. Take all the big numerator, times it by 0.10, and that's your threshold for when you have to obtain competitive bidding. Maybe best practices dictate that you should bid all of your contracts, but you're not required to unless it is above and beyond that threshold. Developer contracts, for those of you who have turned over recently, if you're in a condo, guess what? You can terminate these things. If you're stuck with a long-term, say Comcast, not to knock Comcast, but if you're in a long-term cable agreement that you don't like, and it's 15 years and you're 8 years into it, and it's because the developer entered into it before turnover, you can cancel that thing. The members have to approve it, but you can cancel it. HOAs, you got screwed, all right? You don't have the right to do that. The HOA statute says that any contract for more than 10 years must be fair and reasonable, which is the lawyer's wheelhouse, right? What does fair and reasonable mean? Who the heck knows? So it's critical to know that if you're in a condo, that maybe you look at some of those long-term contracts. If you just turned over, maybe you don't have to stick with them for another 10 years. So management agreements, I'll leave for the last one, so make sure that Craig gets the input on that one. But the last point is this quasi-contract. And this is a point that even if you don't have a written contract, even if you got halfway to negotiating a contract, just know there's this thing called unjust enrichment, which is that even in the absence of a contract, you could be liable for something. So what it means is that if you knowingly accept a benefit to which you know you're not entitled to, you are going to owe that person for the value of what you got. So the textbook example here is that you're sitting on your front porch and you see a contractor walk on your lot every day with wood and nails and a hammer. And you know he's on your yard, and you sit there drinking your coffee and he's building you a gazebo. He comes the first day and he puts the foundation down. He leaves, comes back the second day, gives you a wave and hi, you wave back, say, hey, looking good. Gazebo looks great. And he keeps on building the gazebo. So a week later, he finishes the gazebo. You know you didn't hire him. You know he's on your lot. You know that he's there building the gazebo every day. And eventually he walks up to you with a bill that says, here's your good bill for your gazebo. And you say, I didn't hire you for a gazebo. He says, well, what do you mean? I was walking your lot every single day. So in that context, you can get into a situation where you owe for the value of the gazebo. It's also really important because there might be subcontractors involved who might have lien rights, despite the fact there was never an actual contract. So don't put your head in the sand. If you see someone building a gazebo in your yard every day, say something. If you see someone, if you see someone doing something to your property that you didn't authorize, say something. Because the longer you wait, the more it's like you approved it tacitly by silence. Okay. So going back to the last point here, which is management contracts, I just want you to know that there are some statutory requirements, right? You can't just have a contract that says, we'll manage your property for X number of dollars. There have to be some specific requirements and charges and specificity in that agreement. And you see some bad management firms have some bad contracts, which put people in bad situations. So I'll make sure that Craig has an opportunity to jump in here about how they handle this and making sure that there's transparency in what they're doing.
Well, you know, I would say we're equally as concerned about knowing what the expectations are of the board. So contracts are equally as important to a management company like Castle as they are to the board, so that we're crystal clear going in, you know, what our responsibilities are. One of the benefits of being old and being in the business for a long time is our contracts have largely been scrubbed by, you know, attorneys over and over and over. From my standpoint, I actually do the contract negotiations for Castle, just because if you don't overreach and you understand, you know, if you're looking for a fair agreement and you understand some of the things that you talked about today, insurance, indemnification, with or without cause, then it's really quite an easy process. However, I would recommend, you know, when we take over associations, we're almost always 99% of the time working through the attorney on our contract, just to make sure, you know, the boards have abided by the reasonable business judgment rule and that everybody's on the same page. But we see lots of interesting things when we're taking over associations that are looking to change with respect to the agreement they're in. And one of the big surprises is I can't terminate it, or it automatically renewed and those types of things.
Great point. So I think if I go to the next slide, I think that we are effectively in the Q&A section. Craig, if you have anything else out there.
Steve, that was excellent, excellent presentation. I do have some specific questions. One of which is boards concerned about basically releasing the reins. Everything was shut down not too long ago from an amenity standpoint. Now we're starting to get them opening up again, and we've seen a couple of questions, and we did in the registrants questions around our exposure as a board if we start reopening amenities and someone comes and because we open they get COVID-19. Mm-hmm. In your comments.
Yeah, so I knew we weren't going to avoid COVID-19 today, right? So the answer is that, well, you have to think about the things like indemnification and insurance. So we know that insurance is probably not going to be available if someone gets it and they sue the board. So then you want to know what your indemnification provisions say. Is the association going to pay for my defense and damages irrespective of insurance coverage? Is it available? And knowing that anything that you do, there's liability. There's liability with walking out the door every day. We always say you can sue a toaster in Florida, okay? So what that means is that when you go to reopen, you need to know what you do well and what you don't do well. And if you're going to commit yourself to doing something, make sure you can do it. What I mean by that is if you're going to tell the community that you're going to wipe down the handrails and the gate to the pool every hour, you better make sure you can and you are doing that. If you're not wiping down the handrails every day and someone's watching that, they're going to say that they got it because they touched the handrail, and but for your failure to follow your own self-imposed cleaning requirement, I wouldn't have gotten sick. And now you're in the rock and hard place. So as directors, when you're deciding whether or not to open or not, you have the discretion to do it under the emergency powers. You may have a local county ordinance that says how you do it or whether you can do it, specifically Palm Beach, Broward, Miami-Dade counties. But if you're allowed to do it, you can open. Many of our clients never even closed. But if you're considering reopening, we say two things. One, make sure that you have a sign, right? That's as good as a sign waiver. That sign should say things like, even though we're cleaning more, we can't guarantee a germ-free environment. Number two, talk to your healthcare provider before you walk through the threshold of this amenity. Number three, exercise social distancing. And number four, by doing this, you use it at your own risk. All right, so those are ways that you can mitigate your liability, mitigate your exposures by telling people when you use it, you knew the implications of going about it. But that also assumes that you're holding up your end of the bargain. All right, so when you jump out of an airplane, you sign a waiver. And that waiver says, I hold you harmless. I recognize that jumping out of an airplane is dangerous. But what it doesn't say is it doesn't say that you can be negligent. It doesn't say, skydiving company, be all the negligent that you want. Don't worry about it. What it says is that I recognize jumping out of an airplane is dangerous. And if I jump out of an airplane, I might get hurt. And so the same thing goes here, is that you can tell people they assume the risk by using the amenity, but you still have to hold up your end of the bargain. And so if you have precautions, if you have procedures, make sure you can do it well. Do you really want the guard attendant screening everybody who comes through, doing travel history reports, putting a thermometer in their ear, and trying to tell people that we're doing everything we can to keep you safe and that we're screening everybody to keep the virus out of our community? The more you do that type of stuff, the more you create the duty to do it prudently and reasonably. And unfortunately, we're not built for this stuff. As a homeowners association, you might have the best of intention with great professionals and doctors on your board, but you're not built to take temperatures. And so know what you do well, know what you don't do well, and making sure that you do what you say you're going to do. And if you do all those things, you should have the ability to tell people that you assumed the risk when you did it. And we were reasonable and we prudently carried through the duty we told you we were going to do. And so therefore, we will definitely not be grossly negligent under our documents, so we should have indemnification. And we also should have little or no exposure because we followed the recommendation of the attorneys and management. And we looked at the CDC website and we took actions in response to that under emergency powers, and we carried through what we said we were going to do. So if you do all that, I think it doesn't eliminate liability because you can't, but it minimizes it pretty well.
Steve, I think that's great guidance. And what we're telling our associations is have a plan. So, kind of have a framework, which is, okay, what is your local, municipal, the lowest level of regulation you have to comply with? does it comply with what's going on in the Florida level? Have a plan, communicate the plan to residents, like take the reasonable steps, like you're saying, to protect yourselves. Listen, Steve, our time is up, and I wanted to thank you. We have a couple more questions here, which we'll get to offline. We'll get back to you. There's one question about the renewable management contract. I don't want to answer that until I know if David's a member of one of our boards, and if he can go to bid. So we'll clear that up. First. But Steve, very informative. We talked about contracts, important provisions of contracts. I learned a lot about indemnification and those types of things. We talked about termination with or without cause, and having an addendum to add to every one of your contracts that basically gives some basic coverage to the association. Talked about limits of liability, a lot about insurance, some specific situations, special situations. So, Steve, I want to thank you for joining us this afternoon. I'll look forward to getting together again when the dust settles on all these CDC guidelines. So, thank you very much. I really appreciate your time, and everybody who's listening, thank you. Stay safe and healthy, and we'll look forward to talking to you again. So, good afternoon, everybody.